Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to another episode of All Things Policy. I'm your host, Shrikrishna Upadhyaya, and my guest today is Ritwika Sharma, Senior Resident Fellow and Lead, Charka, the Centre for Constitutional Law at Vidhi Centre for Legal Policy. Welcome to ADP, Ritwika, and wish you a very happy New Year.
Thank you. Thanks a lot, Shrikrishna, and a very happy New Year to you too.
Thanks. So today we'll be talking about the anti-defection laws in India, and we're going to have a very detailed conversation because Ritwika is an expert in this field. She's been researching in this for many months now, and she has a very important and insightful points to make regarding the text of the anti-defection law contained in the 10th schedule of the Indian Constitution. But before we get into all the technicalities here, I'm sure like every person who is aware of Indian politics has heard of disqualification and defection and horse trading and jumping political parties and bringing down government, resort politics and whatnot, right? Because these things are so commonplace. State governments keep changing all the time around us. And most of these are contentious. Political parties fight it out. There's a lot of horse trading, as we call it, involved, and so on. And in fact, this phenomenon has a very infamous name, Ayaram Gayaram, which actually dates back to the 60s and 70s, because defection in India by legislators is not a new thing at all. In fact, what happened in Maharashtra last year is a culmination of a series of developments that have taken place in politics as well as law over the years, and we will be seeing how it all came about. So before we sort of get into Ritwika's work and her insights on anti-defection in India, let us look at why this is a problem, right? This has been perceived as a problem because it betrays the mandate of the people. In India, people stand on party tickets and they win on party tickets. And when they leave that political party to join a new one or make a new party, it sort of defeats the mandate of the people. This has been the rationale behind having the anti-defection law. And just to sort of give you a trivia on how serious this problem was, I was just looking this up earlier today, and I found that, in the first Haryana assembly, around over 40 MLAs had defected. And this was somewhere in 1966 or 67. And the stats are mind-boggling because one MLA had actually defected 5 times, 2 MLAs had defected 4 times, 3 MLAs had defected 3 times, 4 of them had defected twice, around 34 MLAs had defected at least once. So this was the scale of problem. And how did the Indian state respond to it? They enacted constitutional amendments to bring in the 10th schedule of the Indian Constitution, which contains anti-defection provisions. So Ritwika, why don't you begin by telling us what exactly is the content of this amendment and how did it come about and what were the changes which actually happened in the later years?
Sure. Thanks a lot for that introduction, Shri Krishna. I'm very happy to be here. I'm always also very happy to talk about the anti-defection law. And one of the reasons why this intrigues me a lot is, and again, I was also doing some research generally on this topic before we were set to record this podcast. Shri Krishna, I must tell you, and I must tell our listeners also, that our law minister, and despite everything that you've just said about how defection clearly is a pressing issue at this particular point in time, our law minister, in a recent a written response he submitted to the Rajya Sabha, he said that there's been a substantive decrease in defection cases after the insertion of the 10th schedule, and there is really no need to amend the law. And when I think about statements like these, and when I think about the kind of research that we are doing, at one level I feel, is it even worth it? But then, exactly as you pointed out, this clearly puts a major dent in representative democracy in India and how we think about political parties and elections. So here we are, me along with my colleagues at Charka have been looking at decisions that have been delivered by speakers and chairpersons on disqualification petitions that have been filed through the years. Coming to what the law actually says, you've actually given us some very interesting numbers on how many defections, particularly the state of Haryana was witnessing back in the late 60s and 70s. Particularly intriguing figure that I think has become one of those historical facts that everybody wants to state on defection is of a certain MLA in Haryana who switched parties thrice in a day, which I think set off the proverbial Aya Ram Gaya Ram to refer to defections in India. So the spate of political defections continued in the decades following the 1960s, 70s, and ultimately in 1985, we had the 52nd Amendment to the Constitution, which inserted the 10th schedule, which is now what is known as the Anti-Defection law. I'll quickly talk about what this law says. Now, the 10th schedule disqualifies an elected member in case they cross the floor in one of the following ways. And the ways in which an elected member might cross the floor of the legislature is first, if that's the member of a house belonging to any political party voluntarily gives up membership of such party, or if they vote in the house against such party's whip. So you voluntarily shift party allegiance or you vote against the party whip in the house. In case of an independent candidate, if a member has been elected as an independent candidate, if they join any political party after their election, they are also subject to disqualification. So these are the two conditions under which an elected member can be disqualified for defecting. The third is in case of nominated members, as we know, there are also nominated members in the House. If a nominated member joins any political party after the expiry of 6 months from their nomination, they are also vulnerable to disqualification under the 10th schedule. And there are, of course, exceptions to this law as well, the general rule on disqualification. And Shrikrishna, we can talk about this in due course. What I would like to point out for the benefit of our listeners, of course, we know there are historical facts on what prompted the insertion of the 10th schedule. What I would like to talk about as somebody who researches constitutional law is the implications of this law for the constitution and how we view representative democracy in general. And I would like to give a shout out to Aradhya Sethia, who's a PhD candidate at the University of Cambridge, and his work on this. He's written a beautiful piece on the constitutional biography of parties, where he talks about how, and of course, this is something that most of us may or may not be aware of, I'll not assume a lot of knowledge here, is how political parties, despite being so crucial to representative governance in India, did not find a mention in the Constitution anywhere before the 52nd Amendment. So in no provision of the Constitution will you find a mention of political party or parties. And it's only after the 10th schedule was inserted that this term actually got inserted into the Constitution, or it found a mention in the Constitution. Of course, one can say that it's an incidental reference because, of course, when you're talking about disqualification of an individual because they moved political parties, you will have to mention parties. But what does it mean in principle? Now, Aradhya Sethia in his work says that the important departure that happened after the insertion of the 10th schedule was that initially the Constitution recognized individual candidates as the smallest unit of representation. After the anti-defection law found its way into the Constitution, there was a significant shift from the candidate-centered approach of democracy to a more party-centered approach to democracy. And this is actually very evident, Shrikrishna. I want us to read the parliamentary debates as well when the 52nd Amendment was being debated. If one were to also read the majority judgment in the Quixote-Holohan case, the Quixote-Holohan case is actually, it's sort of a landmark judgment because this is where the constitutional validity of the 10th schedule was challenged on several grounds. I'll not go into a lot of detail, but I just want to point out to one particular observation from that judgment where this is Justice M.N. Venkatachalaya, who says that a person who gets elected as a candidate set up by a political party is so elected on the basis of the program of that political party. So in a way, the political party became the center of the entire of the universe of representative governance. And this shift, I think, is something we need to keep in mind whenever we talk about the 10th schedule and what it means for the constitution representative governance in India at this point.
Thanks for pointing out the history behind the sort of the legal history behind the 52nd Amendment, which inserted the 10th schedule into the Constitution in 1985, I believe. And you also referenced Quixote-Holohan, right? And, that's one of the cases which dealt with the basic structure of the Constitution. And the question was whether this anti-defection law violated the basic structure. And I think it was mostly upheld. And only thing which was sort of struck down for procedural reasons was, I think, paragraph 7, correct me if I'm wrong here, which said that, no court in the country can inquire into disqualification proceedings which are conducted by the Speaker of the House or the Chairperson of the House in case of Rajya Sabha.
Absolutely correct.
So my question is actually about the role that Indian Supreme Court has played over the years in shaping the discourse around defections in the country, right? Now the court has said that it is very well subject to judicial review. So essentially, the interpretation of the law falls in the hands of the court. And even in the case of Maharashtra, we saw that the court has referenced the dispute to a larger bench because it believes certain important questions are pending. But leaving Maharashtra aside, generally on anti-defections, what are some of the key Supreme Court rulings or jurisprudence that we should all be aware of before venturing further into the subject of anti-defection laws?
Sure. This, of course, Quixote Holohan has already come up for discussion, so I might as well first finish what Quixote Holohan started. But given that you generally asked me a question on important rulings with respect to anti-defection, let me just maybe break this down for you in terms of subject matter of what these Supreme Court decisions deal with. So one is, of course, as you've already mentioned, the scope of inquiry of the speaker or the chairperson whenever a disqualification petition is presented before them. The other thing we definitely should talk about is what exactly is meant by voluntarily giving up membership of the House, and how does one assert and how does the deciding authority come to a decision as to whether somebody voluntarily gave up membership of their House? How does that voluntary giving up manifest itself? The third thing that I definitely want to talk about is the interpretation of the merger exemption. And again, I haven't spoken about exemptions till now, but again, I think this will come up in due course. So let me just venture right into Quixote Holohan. Quixote Holohan, as I just mentioned, was that decision was that case where the constitutional validity of the 10th schedule was challenged. I think at this point, I'll briefly also talk about the grounds on which the validity of this schedule was challenged. So you've already spoken about basic structure, and it sort of discusses the basic structure of the Constitution. 10th schedule was challenged in this particular case for being violative of the basic structure or being destructive of the basic structure. And how did that happen? It was alleged that the 10th schedule goes against the freedom of speech and the right to dissent of individual legislators. And how is the 10th schedule doing that? As I had previously mentioned, one of the grounds on which an elected member of a House could be disqualified was for voting against the party whip. And on this particular ground, the 10th schedule was challenged for being violative of the freedom of speech of elected members. The other ground for challenge in Quixote Holohan was with respect to the power vested in the speaker or the chairperson to be the deciding authority on disqualification petitions on grounds of defection. So one of the grounds on which this particular provision was challenged was that the speaker is not an independent or impartial machinery for adjudication of electoral disputes. Because as we know, the speaker or the chairperson are elected in India and they hold office on the support of the majority party. And they're not expected to resign their membership of the political party even after their election to the office of the speaker or the chairperson. So of course, there is an element of bias that may creep in when a speaker is expected to decide on disqualification petitions. Of course, and then there was this ground of the 10th schedule obliterating judicial review by the constitutional courts of the country. Now, the 10th schedule was ultimately the constitutional validity of the 10th schedule was upheld, and the majority judgment, this was a 3-2 split. This was a constitution bench in 1992. There was a 3-2 split where the majority said that the speaker or the chairperson holds a pivotal position in the scheme of parliamentary democracy in India, and they're expected to do and take far-reaching decisions in parliamentary democracy. And the majority did not find any compelling concerns with vesting the speaker or the chairperson with this particular power. And as we know, the speaker and the chairperson is still, despite several policy recommendations of vesting this power in another authority, maybe the Election Commission of India or some other authority, they're still the deciding authorities. With respect to judicial review, as you again pointed out, Shrikrishna, that particular para 7 of the 10th schedule was done away with. What did para 7 do? It said that no court shall have any jurisdiction in respect of any matter connected with the disqualification of a member of the House under the 10th schedule. This paragraph has been done away with because, again, judicial review is a key element of not just the basic structure of the Constitution, but generally how constitutional matters are supposed to be adjudicated upon. So yes, that para 7 has gone, but the rest of the 10th schedule remains. On the question of voluntary giving up of membership, I must mention this one particular case again from the early 90s. This is Ravi S. Nayak. Again, something that all law students have read in law school. This was a judgment from Goa where disqualification petition was filed against MLAs who moved parties. They were MLAs from the Maharashtra Gomantak party. I might as well chip in some of the research and some of the data we've collected from Goa, where actually several defections have taken place over the course of the last few years. Again, Goa is a small legislative assembly and several defections have happened there as well. So Ravi S. Nayak was a case where, again, the question of what constitutes voluntary giving up of the membership of the House is what exactly does it amount to? So The 10th schedule, as I said, states that a member may be disqualified if they voluntarily give up their membership of the House. The Supreme Court here said that the Speaker could decide that a member had voluntarily given up their membership based on their conduct, even without a formal resignation. So clearly, this was expanding the scope of how a speaker or any deciding authority is to construe voluntary giving up of membership. So eventually, in this case, the court held that the speaker's decision to disqualify the members was unlawful, and the speaker's decision was quashed on several grounds. But yes, the scope of what exactly constitutes voluntarily giving up membership of the House was sort of broadened here. The other decision I would like to mention about the scope of inquiry on what speakers can do when a disqualification petition is filed before them is from a 2020 Supreme Court decision in Srimant Balasaheb Patil versus Speaker Karnataka Legislative Assembly. And I'm sure a lot of people might actually remember this because this was after the 2018 Assembly elections in Karnataka. The Congress JDS coalition had formed government, and then there were certain defections in July 2019. So what the Speaker had done here was that the Speaker disqualified these defecting MLAs. There were about 13 to 17 MLAs who had defected. After taking all facts into consideration and after applying their mind to the entire fact situation, the Speaker disqualified these members till the end of the term of the Assembly. And this particular aspect, that the Speaker disqualifying the members till the end of the term and also barring them from contesting in elections during this particular time, during the term of the Assembly, that particular aspect was challenged before the Supreme Court. So just to clarify, what the Speaker did here was the Speaker first of all disqualified the defecting MLAs till the end of the term of the Assembly, and he also barred them from contesting elections during this particular time. So this particular aspect was brought in challenge before the Supreme Court, and that's where the Supreme Court says that the Speaker is not empowered to disqualify any member till the end of the term of the Assembly. I mean, there are several other ways in which the Speaker might penalize defecting MLAs or MPs. They could provide a bar from them being appointed as a minister or from holding any remunerative political post. And just by the way, Shrikrishna, all of these are provisions that the Constitution has on how these defective MLAs can be penalized. There is Article 75 1B, 164 1B. But yes, barring them from contesting elections during the term of the Assembly is something that the Speaker was not empowered to do. So yes, there's this bit of, if I may say so myself, there's this bit of a tussle on what the speakers can and cannot do within the realm of their powers that always comes up for consideration before the Supreme Court. There's also, of course, a body of case law on how to, particularly High Court case law on how the merger exemption is to be interpreted, but maybe we could come to that in a bit.
Right. So just to wrap up, I think we've opened a can of worms here, like all the kinds of like issues that come up in dealing with anti-defection law. But just to quickly wrap up, so the first point I think which is very fundamental is anti-defection law has a direct impact on the freedom of expression of legislators. The fact that they have to vote as per their party's whip and they cannot take a decision as per their individual conscience is not how Indian democracy was at least initially conceptualized. But like you used Aradhya Setia's work to point out that we have moved away from a legislator-centric democracy to a party-centric democracy thanks to 10th schedule in place. So that's the first thing. And the second is, of course, the element of bias. And I think one point which has to be taken note of here is 10th schedule does not prescribe any time limit within which the Speaker has to decide on a disqualification petition. This means that the Speaker can act according to his convenience. If he wants to support the government, he can sort of act immediately on it. If he wants to support the opposition, then he can sort of delay it. And this has actually real consequences. We know that, like, for example, in West Bengal right now, an opposition MLA joined the ruling party, and the Speaker simply did not decide on the disqualification petition till the Supreme Court or the High Court ordered him to do so. So that element of bias is hard-coded into the law in the sense that we really cannot escape from it. And the third important point, again, like you said, the wordings is in one of the grounds on which you can be disqualified is voluntary giving up of your membership, right? And like you rightly pointed out, this is again objective. Formal resignation is a hard standard, but the court in Ravi Nayak's case, like you pointed out, said that, this is much more broader than just formal resignation. Now, some, I think, speakers and even high courts have accepted this. If you can let me know if you have case laws on this. The fact that anti-party activities are being engaged in by a legislator has become a ground for disqualification, right?
Right. In fact, given that there is... I'm so sorry. Yeah.
Yeah. No, go ahead.
because the wording of the this particular 10th schedule is such that it's open to several kinds of interpretation. There's also this very compelling concern, because you mentioned anti-party activities, it just came to my mind. One of the concerns has been, are we talking about conduct of a legislator within the house? Are we talking of conduct of a legislator outside the house? When we're talking of legislature party, are we only talking about, I mean, of course, legislature party has a certain established meaning within the 10th schedule. But again, about these concerns about when we are talking about conduct of a particular legislator with outside or inside the house, these are very compelling concerns for freedom of speech and expression of individual legislators. And yeah, and I mean, none of the case laws are coming to my mind right now, but yes, there is a body of Supreme Court as well as High Court case law that provides these varying interpretations of this particular 10th schedule. So when the law minister says that there really is no concern with respect to the anti-defection law, I think a lot of these interpretative concerns are actually not being taken into account. And we have a very myopic view that, okay, let's say before 1985, the anti-defection law could curb, there were maybe 20 defections happening, and now it's brought it down to 10. So clearly the law is working. But that again is a very myopic vision of this law.
Right. And we are only halfway through the podcast, so I'm sure like a lot more interpretive issues will come up with 10th schedule as we progress. But I think this is a good point to pause and take a short break, and we'll come back on All Things Policy with Ritwika Sharma.
Sure.
Welcome back to All Things Policy. We are in conversation with Ritwika Sharma on anti-defection laws in India. So Ritwika, from you, I understand that you've been researching into this issue for quite some time now. You've gone through the petitions that have been filed before the speakers and the decisions of speakers right from 1986 when this law came into force. And you have some insights to offer, especially on an exemption. I think we referenced it in the first part of this podcast, but we'll discuss it in much more detail now. And you have done quite a bit of work on merger provision. So I want to know from you, what is this merger exemption exactly? How is it different from a split of a party? Because I believe split was one of the earlier exemptions which was granted but was taken away by constitutional amendment somewhere in 2003. So what are the issues surrounding merger today?
Sure. So, Shrikrishna, before I jump into the issue of split and merger, the kind of work that we are doing at this point, I'll just take about a minute to tell you what we are up to at this point. So, we thought it would be a good idea to actually look into the text of decisions given by speakers and chairpersons in defection petitions that have been filed before them since 1985. 1985, as we mentioned, is when the law came into force. A quick caveat on that, though, is the fact that our sample size is fairly, I mean, I don't know whether it's fairly small or fairly large, but in terms of timelines, we've only gone through decisions till 2004, and that's primarily because the kind of information we have right now takes us only as far as the early 2000s. And we'll have to profusely thank Mr. G.C. Malhotra, who was formerly Secretary General of the Lok Sabha. His treatise on anti-defection law actually very helpfully puts down decisions from 1985 till the early 2000s. So that's where we are at this point. We've actually gone through some...
Sorry to interrupt here, but I wanted to know, what is the challenge you're facing in accessing these petitions and decisions of speakers?
No, the only challenge is one of availability. So, yeah, that's about it. I'm sure we'll be able to find the text of decisions post 2004 as well. So maybe Gazette notifications are actually going through certain other information available on the Lok Sabha and the Rajya Sabha websites. So yes, coming back to exemptions, that's something that I've already spoken about. I've spoken about the grounds on which an elected member or a nominated member can be disqualified under the 10th schedule for crossing the floor of the House. The anti-defection law, even at the time when it was brought into force, had two exceptions. And what were these two exceptions? The first was in case there was a split in a political party, and second was in cases of mergers between political parties. And I'm sure the split provision, the split exemption has gone now. It was done away with in 2003, as you mentioned, Shrikrishna. The merger exemption still remains. Now, what does the split provision say? Or what did it say? Now, it doesn't exist anymore. The split provision exempted a member or a group of members from disqualification from a political party if at least one third of the members of that political party formed a separate group. So basically, if a group of one third strength of the legislature party, they formed a separate group, one third being the key number here. If they formed a separate group, they would be exempt from disqualification under the 10th schedule. What happened was, owing to excessive misuse of this provision by political parties, many of whom engineered splits. They somehow could gather the numbers, they could engineer split. This exemption was omitted from the 10th schedule in 2003 by the 91st Amendment to the Constitution. I'll just quickly actually mention a few numbers from the data also that we collected. So we have numbers, we have we could lay our hands on about 49 decisions between 1986 to 2004 on disqualification petitions filed in the Lok Sabha before the Speaker. And Shrikrishna, I must point out that about 38.1% of these petitions that we found, the reason that particular floor crossing legislators gave while crossing the floor was that they were splitting to form another political party. So clearly that concern about the split provision being misused was validated when we actually looked at all of these decisions from 1986 to 2004. So the split exemption is now gone. The merger exemption still remains. And Shrikrishna, should I just venture into explaining what the merger exemption is?
Yeah, please do. I think it will help.
Sure. So when can political parties be said to have merged under the 10th schedule? And I really request the listeners to bear with me for a moment, because it's not me, but actually the Constitution that has some very, very technical concepts here when we are talking about the merger exemption. So paragraph 4 is the particular paragraph under the 10th schedule that talks about the merger exemption. It talks about two kinds of entities. One is the original political party, and the second is the legislature party. What is the legislature party? The legislature party, and I'm sure these terms might sound actually very self-explanatory. A legislature party is the group of elected members of a house for the time being belonging to one political party, whereas an original political party means the political party to which a member belongs. And of course, the original political party will definitely have members outside of the legislature as well. It's generally all the members of a particular political party. So how does the merger exemption work? So a bare reading of this paragraph 4, the merger exemption suggests that a merger can take place only when an original party merges with another political party, and at least 2/3 of the members of the legislature party have agreed to this merger. So the original political party merges with another political party, and at least 2/3 members of the legislature party agree to this merger. If these conditions are satisfied, the group of members which merge with another political party, basically the group constituting the 2/3 or more members, cannot be disqualified on grounds of defection. And this is the consequence of the combined reading of the two sub-paragraphs that paragraph 4 is split across. So the problem here is, and Shrikrishna, I might as well actually just mention this, what I just explained has been drafted in a rather convoluted manner in the Constitution. And that is where paragraph 4 has exposed itself to multiple interpretations. And should I actually talk about multiple interpretations, or Shrikrishna, do you think that was clear enough?
No, I think you can point out a couple of them and let our listeners know.
Sure. So what happens is, as I said, this paragraph 4, this merger exemption is actually split across two paragraphs. And these two paragraphs say what I just mentioned. The second subparagraph of paragraph 4 says that a party shall be deemed to have merged with another party. Deemed, and again, I'm making these air quotes right now if my listeners could see me. They're deemed to have merged with another party if and only if not less than 2/3 of the members of the legislature party concerned have agreed to such mergers. Now, I think all of us know that in most cases, there is no factual merger of original political parties at the national or even the regional level. We can never expect a Congress to merge with the BJP or even major regional political parties merging with each other. Paragraph 4 creates something that is called a legal fiction. And my apologies because I'm clearly delving into some legalese here. But paragraph 4 is actually creating a legal fiction so as to indicate that a merger of 2/3 members of a legislature party can be deemed to be a merger of political parties, even if there is no actual merger of the original political party with another party. So that is how high courts in India are actually interpreting the merger exemption. I'll just point out one quick example here of how high courts are interpreting this merger exemption. So in 2019, again, this is a fairly recent example, about 12 MLAs in the Goa Legislative Assembly. I'm talking Goa again here, and this is not intentional. It just so happens that Goa came up several times while we were researching the Anti-Defection law. So in 2019, 12 MLAs in the Goa Legislative Assembly who belonged to the National Congress and the Maharashtra Gomantak Party crossed over to the BJP. So this is INC and Maharashtra Gomantak Party MLAs crossing over to the BJP. The Speaker of the Assembly as well as the Goa bench of the Bombay High Court dismissed the plea seeking disqualification because both the Speaker as well as the High Court held that these 12 MLAs formed two-thirds of their respective legislature parties. So here we are seeing MLAs from the Congress as well as the Gomantak Party, Maharashtra Gomantak Party, moving to the BJP and not getting disqualified because the members who crossed the floor formed two-thirds strength of the actual legislature party of both these parties. So clearly, the High Court as well as the High Court's the Speaker said that there was no disqualification under the 10th schedule. So in other words, there was a deemed merger of the Indian National Congress and the Maharashtra Gomantak Party with the BJP. Again, not my words, but the High Court's. This is a High Court decision from early this year. This was a High Court decision from February 2022. So this is where the problem is, because this deemed merger is one of the provisions under the merger exception. In a lot of the smaller legislative assemblies, it is very easy to muster up two-thirds strength of a legislature party to actually give effect to a merger. So basically, it's very, and I think we've seen this happen in several smaller as well as larger legislative assemblies. And I mean, if I may just point out some of the examples, I think this happened in Arunachal at one point. This definitely happened in Karnataka. Very recently, this happened in a bigger legislative assembly. Even Maharashtra could have been one of those cases of the merger exemption being put to not the best use. But yes, this is the current issue with the merger exemption, Shrikrishna, that given that its language is so convoluted, it is open to multiple interpretations. Again, in legal parlance, we can refer to a conjunctive as well as a disjunctive interpretation of paras 1 and 2 of the merger exemption, but I'll not go into that. But yes, this is where we are in terms of the merger exemption. It's become rather convenient for people to muster up the strength, the two-thirds strength. It's basically math at this point. And that's why the merger exemption is clearly problematic right now.
Sure, but I still have a very basic question, which is how does this merger exemption now, how is it any different from the split? Because earlier, one-third could just split the party and join another party, and they would have the exemption, the protection from the exemption. And this provision was done away with. And now we have a situation where you just need two-thirds instead of one-third, and you're deemed to have been merged with another political party, which in my reading seems like the split provision has made its comeback through a back door, except with like a two-third requirement now. Is that a right reading?
In effect, yes, it's come down to exactly that. And if you look at a lot of policy recommendations over the last 20 odd years, they say exactly that whatever the problems that we were facing with the split exemption is now emerging in the form of the merger exemption. Of course, the only difference being in split, once you gather the one-third number and form a separate party of your own, you're sorted. You don't have to go and merge with another political party. Here in two-thirds, the merger exemption says that you gather strength, you gather two-thirds, the required number, the two-thirds strength, and go and join another political party. So what was happening in split was a lot of these people who were splitting were just forming factions of their own. And I'm actually very happy that you've asked this question, Shrikrishna, because then I can again very subtly chip in some of the information that we have from all the data that we've collected. And so there is a certain phenomena that emerged in the late 90s and early 2000s. Again, this is not, I'm not using any term of art here, but this is just based on some of the information we've collected. What was happening in the late 90s and early 2000s was something called splits followed by mergers. Again, nobody's calling them splits followed by mergers. This is just something that we've come up with in our work. So what was happening was, and this is again based on data that we've collected from the Legislative Assembly in UP. So some of the elected members, they would gather the numbers, they would somehow muster up the strength of one-third of the legislature party strength, split from their particular party, make a faction of their own, and then go back and merge with another bigger political party. And if I may just quote from some of the data that we have, between mid-1990s to the mid-2000s, over a period of 10 years, many of these smaller factions ultimately ended up merging with the Samajwadi Party. And again, this is purely coming out of the data that we did. And Shrikrishna, if it's all right, I'll actually just spell out an example that we found really comical. It's very worrisome if you think about it, but it became rather comical when we were reading about it. So there was a certain MLA from UP, this was late Mr. Rajaram Pandey, who commenced his political career in the Janata Dal. In 1997, he split from the Janata Dal to form his own faction called Janata Dal Rajaram Pandey. So this was basically Janata Dal and within parentheses Rajaram Pandey. And this is how splits were happening. Somebody would just split from a larger political party and form a faction of their own, and that faction, everybody who formed part of that faction was just member of this new political party. So basically, at the end of a split, the product was a new political party. And these new political parties are basically factions. So in 1997, Mr. Rajaram Pandey split from Janata Dal to form a faction, Janata Dal Rajaram Pandey. He merged this faction with the Lok Janshakti Party. So this is basically, he split and then he merged with another political party. He then split from the Lok Janshakti Party to form a faction called Lok Janshakti Party Rajaram Pandey. So again, he made a faction from the Lok Janshakti Party as well. He then merged this Lok Janshakti Party Rajaram Pandey with the Samta Party. Again, I'm sure at this point you figured what trend he's following also. He then split from the Samta Party to form the Samta Party Rajaram Pandey, again within parentheses. And then finally, he merged with the Samajwadi Party in 2003. And this is where Mr. Pandey remained till he passed away in 2013. And this continuous splitting and merging kept happening till the split exemption was done away with in 2003. So again, coming back to your initial question, at the end of the split, a particular faction could just be a standalone political party. At the end of a merger, and as we are seeing in the current trend in merger is, of course, you split from a party in the opposition, and then you sort of go and merge with the ruling party. Of course, there are other ways in which mergers are currently working. Currently, mergers are working to destabilize incumbent governments, as we saw in MP as well in 2000. Correct me if I'm wrong, and this was in 2020.
Yeah, just
where exactly, this was just before I think the pandemic struck, where people sort of gathered the numbers. And this is actually also what Venkaiah Naidu said in one of his speeches at some point last year, where he said, currently the merger exemption is facilitating wholesale defections. So you somehow gather the numbers, get 2/3 MLAs to come with you and rock the boat for the incumbent government. And then, of course, we know how these trends work. You go and join another party, which then somehow manages to gain majority. And then the incumbent government, of course, gets destabilized. So yeah, this is where we are in terms of splits and mergers. And yes, you're absolutely right when you say that the merger exemption currently is doing exactly what the split exemption was doing back in the late 90s and early 2000s.
You know what? I think, first of all, Rajaram Pandey should have just named his party Rajaram Pandey Party and then put it in the brackets, Samta Party, LJP. I don't know why he didn't do that. But in any case,
Rajaram Pandey is only one of the. I'm so sorry. I just need to, because I find this really comical and amusing. It's not comical, I know, but there were many instances of many such legislators from UP doing that and ultimately ending up in the Samajwadi Party. I'm not trying to impute any intentions here, but then again, this is what the data told us.
Sure. And the other thing, I think what sort of stands out in, at least in recent memory, is what happened in Maharashtra, right? And I don't think we have a final determination on this point of law because the Supreme Court is yet to rule on the... But what I think Shinde did after he split from Shiv Sena was that he claimed that, there is no need for a merger because right now what he has is the support of the majority MLAs. So in essence, it is the same party which has just undergone a change in leadership. So the Shiv Sena remains as is, the legislature party is the same. So there is no question merging with the BJP, just that the leadership of Shiv Sena has shifted from Uddhav Thackeray to Eknath Shinde. So what do you think of this claim?
So again, this is one of the issues that came up for consideration, was whether a split in an existing party where nobody is actually moved, it's a split in an existing party and nobody is actually moved outside the legislature party or outside the umbrella of this particular party, whether this constitutes defection, or whether people who've done that, they're subject to disqualification under the anti-defection law. And also in Maharashtra, I must actually point out that there are several other considerations that have gone into this entire dispute. There is this entire fight over the symbol. Of course, the Election Commission of India then asked that nobody could actually have claim over the particular symbol that they were fighting over. Everybody's supposed to have new symbols. But then, see, one thing I think a lot of people are not talking about when we talk about the anti-defection law is the stability of the government and how all of these provisions are currently being used to destabilize incumbent governments. Even in Maharashtra, I know we started this discussion with Maharashtra, but I cannot not talk about in Madhya Pradesh also in 2020. And why I talk about Madhya Pradesh very, very strongly is because in Madhya Pradesh, when the government, the Kamal Nath government was destabilized and was brought down, we must also remember that this was the exact time when the pandemic struck. So if I recall correctly, and this is only based on news reports that I had read from back then, we were in the throes of the pandemic while MP did not have a health minister. So clearly, we must also be acutely cognizant of the fact that provisions of the 10th schedule are actually being used currently to destabilize incumbent governments. And that's something that should not be allowed very easily. With respect to, again, coming back to Maharashtra, there are several other questions also which are currently up for consideration. And this entire question of whether a split within a political party, again, I do not have a very concrete view on this. But again, these splits within political parties also, again, rock the boat for incumbent governments. And maybe there should be some clarity within the law of the 10th schedule, clarity within the language of the 10th schedule also about how such splits are to be dealt with. Currently, I think the 10th schedule doesn't have anything solid on that.
Right. There is one related issue, and I think you have done a bit of research on this. And moving away from merger, in fact, this is the curious case of unattached legislators, or those poor souls who have sort of been expelled from their party for whatever reasons. Maybe they spoke against the leader, or they gave out some controversial statements like our legislators love to do at the time. But they get expelled from political party, but they still hold on to their membership of the House or the Legislative Assembly because they are elected members after all. So what happens to them once they are expelled? Are they allowed to join a new party? Because technically the mother party does not want them. They are abandoned.
Yeah.
Or will anti-defection law prevent them from moving to a new house? In a sense, moving to a new party.
Thanks a lot for that question, Sri Krishna, because we were also mulling about what exactly happens to expelled members. And one of the reasons why we even started thinking about expelled members was because the kind of data that we surveyed, we saw in several cases, the disqualification petition actually was filed against expelled members. So the first question was, actually not the first question, but the first thought we had in our minds was that anti-defection law actually does not address or say anything at all about expelled members. But yes, I should mention that the original draft of the 10th schedule, it did have an additional section 21C, which specifically made the schedule applicable to expelled members. So I think I should get this out of the way immediately. But during the course of the debates, this additional section was actually dropped from the final version of the schedule. And if one were to actually look through the parliamentary debates from 1985, they'll see why it was dropped. What were the reasons why it was dropped? Because multiple members, they drew a distinction between what constituted defection and what constituted dissent. And they said that somebody who's already been expelled, you subject this particular person to defection proceedings again, clearly they'll also lose their right to dissent against anything that the party is doing. So yes, there was this one attempt to actually insert something on expelled members, but it never really saw light of day. Where we are currently in terms of the application of the 10th schedule to expelled members, in all honesty, there's no clarity. There's no clarity, and this is despite the fact that Amar Singh, as we know, was expelled from the Samajwadi Party at, I think, sometime in 2011. He had actually brought this exact question before the Supreme Court, and he wanted to know that when a member of either House of Parliament is expelled by the party that had set him up as a candidate for election, when they join another political party or form their own party, can it be said that they had voluntarily given up membership of the party? Basically, can you institute disqualification proceedings against them? Now, this matter came up for hearing in 2011 and there was no final decision on it. In 2017, this matter was actually referred to a constitution bench, but we've not had any final decision, final determination on this by the Supreme Court. So currently, despite Amar Singh's multiple attempts, as I said, there are 2 attempts that he made to actually gain some clarity on this. There's no clarity on this at this point. But I must mention that, and I keep going back to this one Janata Party split case from 1992, exactly, where Shivraj Patil was a speaker back then. There were certain members who had split from the Janata Party who were also expelled members. And again, Shivraj Patil, who was the speaker back then, he expressed the exact anguish, saying that there is no clarity with respect to expelled members. So there's this lack of clarity that's gone on since 1993 to 2023, which is rather telling at this point. So yes, the long and short of it is that there is no clarity on whether the anti-defection law applies to expelled members or not. And there's also this particular mention of unattached members. Again, unattached members is not a term of art. It doesn't find mention under the 10th schedule. So yeah, this is where we are.
Right. Thanks for this exhaustive discussion on anti-defection law provisions in the Constitution, the history surrounding them, and the critical issues that still require final settlement. And it sort of has left me on a pessimistic note, to be honest, because it seems that when it comes to the current anti-defection law, the cure seems to be worse than the problem itself, right? What we went to tackle was problem of indiscipline, party indiscipline, horse trading, money shifting hands, all things which are bad for democracy. But today we have the same things going on, except with a lot more procedure involved. And it seems that all parties who are involved, the speaker, the legislators, the political parties, have found workarounds which defeat the object of the 10th schedule. And of course, there is this overarching question as to whether such a law is in fact desirable at all. And in fact, when a law minister says that, the number of disqualifications has come down, maybe the precise reason is that everybody knows the loopholes in law now and they exploit it perfectly. So there is no question of disqualification. The speaker might just desist from taking a decision. The political parties might engineer two-thirds splits or mergers, as the law says. And in fact, the same tamasha goes on and everybody is happy at the end of the day and the law remains on paper. So do you have any bright ideas which can bridge the gaps, the problems that I have sort of talked about now, and leave all our listeners on a more optimistic note than I have?
I think, first of all, my sincere apologies if I've clearly sort of fueled this discussion with a lot of pessimism. But I think a good point to start would be to acknowledge the fact that there's a problem here. I mean, if you live in denial and say, no, clearly, and as I said, I'm using the term myopic the third time in this discussion. But if you just say that, okay, so the number of defections have overall decreased, perfect, that's you could ask for nothing better, then I'm sorry, I think that this is the precise problem that we need to address. We need to address the fact that this law, everybody's, as you rightly pointed out, Shrikrishna, everybody's figured what the loopholes are. It's very easy to play with this law. Again, I'm going back to the data that we surveyed, and across between 1986 to 2004, which is broadly the period we surveyed, there were very few actual disqualifications in the Lok Sabha, Rajya Sabha, and the UP Legislative Assembly, which is what we have surveyed till now. So I think that by itself tells you that it's not as if defections have decreased or have reduced. It's only that people have figured their way of how to work around this law. And as I said, this largely at this point, it is, yes, it's a lot of political maneuvering and it's very basic math. It's very basic math about how to do 2/3 and 1/3. 1/3 is gone, yes, but 2/3. I think one good place to start with is, and the Supreme Court actually gives me some hope here. I'll not pin a lot of my hope on the Supreme Court, yes, but I think last year at some point there was an earnest interest in academically reviewing the 10th schedule by the Supreme Court, and a lot of this actually was prompted after the Maharashtra political crisis. So I think this academic revisit of the 10th schedule, as monotonous as it might sound, should account for both party discipline as well as the freedom of speech of party members. And it should happen soon. Maybe at the end of this academic revisit of the 10th schedule, we realize that possibly we don't need an anti-defection law. We need something else to ensure party discipline. Maybe we need some sort of constitutional recognition of political parties and make sure that somehow party constitutions by themselves, I know party constitutions are not something that can be statutorily regulated at this point, but maybe party constitutions by itself should account for more discipline among party members. So yes, one academic revisit of the 10th schedule is definitely required. The other thing is, I think we need to keep going back to policy recommendations of the last few years. I think the last policy recommendation on this particular subject came in 2015 when the Law Commission of India, in its 255th report, again spoke about, and I say again because the Law Commission of the 255th report was not the first time this was being spoken about, but yes, the Law Commission again spoke about how the Speaker may not be the ideal authority to be deciding on disqualification petitions. And Shrikrishna, you also mentioned this a couple of times while we were talking about how there are no set time limits within which speakers have to decide. There is clearly an element of bias which is very, very difficult to do away with. So yes, high time that we fix the speaker situation. Either we get a tribunal of some sort or we get the president or the governor to decide on that on the recommendation of the election commission. Again, these are not my recommendations. These are recommendations that have come from previous years. But the speaker situation has to be sorted sooner rather than later. We've seen speakers run amok with the 10th schedule, and it's high time that gets sorted. The last thing, as a lawyer who's really anguished by the language of the merger provision, it gives me a lot of anguish. If I were to read out the merger provision by memory, I'm sorry, I can't do it till now because it's rather convoluted. The academic revisit has to do something about the merger provision. So yeah, I mean, it clearly is one of those problems that can definitely be solved. But then let's also be realistic. It is one of those problems that nobody would like to solve immediately because once you figure out how to work around the law, why would you want to change it?
True. Thank you so much for joining me today on All Things Policy, Ritwika. It was a lovely chat, and I hope our listeners have a lot of takeaways from this. And yes, of course, I'm sure all political parties and establishments favor the status quo, but we will hope that there is some change which comes in the future in the text of the 10th schedule, maybe through the courts, maybe nudged by the courts, or maybe through the parliament itself, because, surprise would do all of us good here. So thank you once again for joining me.
Okay. Thanks a lot, Shrikrishna. I had a great time.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Taksashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @Takshashila INST or our website takshashila.org.in.